before we get started, I want to just remind everybody in the audience, please silence your cell phones. And, we're going to begin this morning with the case of Sasser v. Sasser. And if you please ask the attorneys to identify themselves for the record.
Chris Donovan, commentator.
Park Ricker, CK,
Okay. All right, Mr. Donovan, you are recognized. How much time would you like to reserve, if any?
5.
Okay. You're recognized.
May it please the court. The initial brief identified 2 grounds for reversal, but today I'd like to focus on just the first ground, stand on my briefs with respect to the second. The first ground asks the issue of whether or not section 90.11.1's 20-year deadline, statute of limitations deadline, applies to support payment judgments, particularly the 2004 judgment. The 5 other district courts of appeal, beginning with the first DCA's Homeowner decision, and then the the 5th DCA's Popper decision, has basically answered this question in the negative, stating that the statute of limitations.
So I was kind of a little surprised the way you organized your brief. You really hit the DCA split hard, and then you said, whatever you do with the DCA split, this was an alimony. And I kind of thought it made sense to do the other person. We don't get into the DCA split unless it's alimony. And frankly, I didn't think it was alimony. It literally says in lieu of alimony. So why did you organize it that way? It seemed to me like the much straightforward issue was this isn't alimony. And I've got some, I don't think that means you win. I've got some questions about it, but
Sure.
Did you find it to be a close call as to whether this is alimony? Because the implication there, you know, the way you organized your brief was you thought that was the stronger argument, was take this side in the DCA split, which I'm not saying you're wrong about which side to take or right. I'm just saying that it seems like I would have expected the first issue, just as a point of logical analysis and strength of argument, to be this isn't alimony. So what am I missing in terms of how you organized your brief?
No, I think that in terms of how I organized my brief, I went back and forth on which one to start first. I think I decided to just go squarely in challenging the other 5 DCA splits, because the trial court didn't really want to hear about the distinction between whether this was alimony or not alimony. And in fact, suggested, although I disagree with it, suggested that my client had somehow conceded that this was alimony. So I decided, I made a split decision. I think that either one of those could have begun first. I also liked the reason why I structured it that way is because then it provides me an opportunity to provide the general law of judgments first, and then move into addressing the exception.
Well, the judgment literally says in lieu of alimony, so I don't think this is alimony. The issue I had with your argument was, it seems to me a little internally contradictory. All right, so you see actions must be filed within 20 years. You know, statutes of limitations, they don't eliminate ongoing actions. It just requires you to file the action within the limitations period, right? So if you file an action or a proceeding within the 20-year time limit, it seems like you have a right to have it litigated. And what you say to that in your brief is that, well, these were motions. They weren't independent actions, okay? So there was no action filed. But then you also go on to say that an action under 9511 includes proceedings, which is broader than actions, and includes any procedural means for seeking redress. And certainly a proceeding supplementary, you know, or a motion for garnishment, of the types of things you would do for execution, those are certainly proceedings for seeking redress. So I guess my question is, wouldn't the types of things at issue here, you know, the motions, proceedings, supplementary, wouldn't they be included within the definition of proceedings that you point out? Because the way it seems to me is you seem to want to say that these are proceedings within the scope of 9511, so they're barred. But if they're proceedings within the scope of 9511, that also means they were commenced within 20 years. So can you square that for me?
Sure. I think that the Supreme Court's decision in Salinas versus Ramsey squared that. And I think they wrestled with a similar tension.
That's discovery.
I'm sorry?
That was discovery, right?
Well, that was discovery, but I think that I don't believe that Salinas was limited to just discovery. It basically said all forms of enforcement of the original judgment. In fact, that all Salinas reaffirmed the Supreme Court's Massey versus Pineapple Orange decision, as well as the Supreme Court's Young versus McKinsey decisions, which concerned execution on judgments and judgment liens. And it approved the Fourth District Court of Appeals Bershon decision, which involved garnishments. In other words, as far as I read Salinas, it was not limiting proceeding as broad. It was not making proceedings.
What was the timeline of the garnishment in Bershon? When was it filed compared to the statute of limitations period? And like, as opposed to filed versus completed. So here's my point. Say you've got 20 years and you get a writ of garnishment the day before the 20-year limit, okay? And the bank actually answers 2 days after the limit or a week after the limit. Have you not commenced your garnishment proceeding within the 20-year limit?
No, Your Honor. You've commenced it within the 20-year limit, but the statute of limitations isn't limited to just proceeding. A garnishment is not an action on a judgment. It requires an entirely independent lawsuit to renew the 20-year statute of limitations, which is basically what Bershon.
No, but I agree. You need a new lawsuit to extend the statute of limitations. I'm talking about whether the statute of limitations was complied with, right? Because a garnishment is the definition you give for proceeding, you pointed out, in the statute that applies, because they define action to include proceedings. It's not just common law action as used in the statute include proceedings, which is any, procedural means of seeking redress. A garnishment is certainly a procedural means of seeking redress. And the statute uses the word commenced, right? So if you file for your garnishment within the 20 years, you've commenced the garnishment proceeding, haven't you? You haven't completed it, but you've commenced it.
You've commenced a garnishment proceeding, but that is insufficient to extend the original judgments.
No. I'm not saying you're extending the statute of limitations. I'm saying you've complied with the statute of limitations, right? Like, just think about a 5-year statute of limitations on a contract claim, or 4 or 5 years, whatever it is. If you file that a week before the statute of limitations, you get to litigate your suit. You didn't extend the statute of limitations. The statute of limitations is still 5 years, but you commenced within the 5 years, right? So you would get to pursue that suit. And that's what the analogy I'm giving with the garnishment is. If you file your garnishment within the 20 years, yes, you might not get to file a new garnishment 2 weeks later because now you're outside the 20 years. But that garnishment was commenced within the 20 years, was it not?
Not according to the Salinas, Massey, and Young precedents, Your Honor, nor I think under the Bershon precedent, which this court's not bound by necessarily, but it was approved by Salinas, that the proceeding for garnishment, proceeding is not as broad for purposes of 9011 that would allow you to avoid 9011 statute of limitations.
What was the timeline for the garnishment in Bershon? Do you know?
Let me
If you
try.
don't, that's okay. You can address it on rebuttal. I don't want to get up your time.
Okay, that's fine. Yeah.
Let me ask you this then. If I think Salinas, I'm not saying I agree with your interpretation of Salinas, but assuming your interpretation of Salinas is correct, what if I just think Salinas is wrong? All right, so I have to comply with all Supreme Court holdings, right? Obviously, I don't have to comply with like logical extensions or dicta, right?
Okay.
So Salinas, whatever you think about how the logic might apply here, concerned discovery, didn't it?
Yes, it concerned discovery, but Massey versus Pineapple Orange, which is a Supreme Court case, I believe it concerned a deficiency execution on a deficiency degree, and it was similar to the scenario that you're asking about, where they filed their levy a couple of days before the 20-year mark, and then the sheriff didn't start trying to actually collect all the property to execute until after the 20-year mark, and the Supreme Court in the 1924 Massey versus Pineapple Orange case said, no, all forms of judgment enforcement must stop. That simply because you obtained, in that case, they had obtained a writ of sorry fate. I'm sorry.
Did the statute in 1924 include the definition of proceeding that it has now?
So
Didn't they have that in the 70s or something?
that, yes, the definition of action was defined under 95.011. It was added in the 1970s. Correct. Yes.
Okay, so I don't think a 1924 case helps you when the definition of the statute at issue here was added in the 70s.
Other than the fact that Salinas approved Bershon's fourth DCA case, which was lied, and approved the Massey decision, and relied on the Massey decision, continue relying on the Massey decision.
But that would be dicta too, right? And then there's, what is there, can you give me anything about a Pedroza analysis on that? Means that's a holding I've got to follow?
I'm sorry, repeat that.
I mean, a kind of a logical approval of we like a case, that's not part of a holding, is it, that I have to follow?
Except that it was part of the, I mean, in dicta, or so the difference between dicta and holding, respectfully, Your Honor, is that all of the reasons that support the underlying decision of the appellate court is holding. Anything out extraneous to that.
Correct, but
is
it's,
dicta.
so it's a Pedroza analysis, right? So it's the decisions in a line of reasoning that lead to the judgment based on the facts of the case.
Correct.
Facts of the case where that was discovery.
Okay, but if, Your Honor, for a moment, let's assume for the sake that you could distinguish Salinas based on discovery. It's discovery in aid of execution. It's not discovery in a vacuum.
Well, but discovery doesn't seek a remedy, right? Discovery is something you gather in order to later seek remedies, right? Whereas a garnishment or, proceeding supplementary, you're going after money, right? I mean, that's much more in line with the seek redress definition than discovery to me, is it not?
What would be the point of pursuing discovery or denying discovery beyond the 20-year mark if you couldn't enforce the underlying judgment? I mean, it's discovery in aid of execution for a reason. If execution is no longer valid after 20 years, then logical extension of that is that discovery wouldn't be, you couldn't continue discovering a judgment that's no longer enforceable. And I think that's part of why the Massey decision and the Young versus McKinsey decision are still valid and not just dicta in the Salinas case, because they were integral part of the decision-making process in reaching the holding in Salinas.
Does it strike you as inconsistent in how you're asking us to interpret how execution proceedings work and collection proceedings versus how actual actions work, right? If you've got a statute of limitations on a contract or negligence claim, you've got a 4 or 5 or 2-year statute of limitations. If you start the proceeding within the statute of limitations, you're golden. As we're in the execution context and the collection context, you're asking us to say the proceedings must be completed within the statute of limitations. That would mean that these proceedings work differently than, statute of limitations on civil causes of action, right?
I don't believe so, not based on how action on a judgment or decree has long been recognized. That as Salinas pointed out, it does require an independent action separate from the original action.
Well, but the independent action, I think we're disconnecting a little bit. Independent action is what you do to extend the statute of limitations. So you're coming up in your 20 years and you've got to file an action to renew it, right?
Okay.
Totally same page. Agree with you there. What I'm talking about is the mechanism for complying with the existing statute of limitations. So in the, breach of contract context, you've got 5 years or 4 years, whichever it is. If you file your breach of contract action within that 4 years, you've complied with the statute of limitations, even if your suit isn't finished until outside the 4 years, right? You just have to file and start it, commence. And in the collection, in an execution realm, you're asking us to treat it differently, that your execution proceeding must just be commenced within the statute of limitations, but must be completed within the statute of limitations. And that even if it's commenced within the 20 years, if you're not done within the 20 years, you're cut off and it ends even though it's ongoing. That's not how the statute of limitations works for, civil actions, right? You're asking us to treat them differently.
I respectfully, I'm not sure that I am. In modern day era, yeah, I can see how it'd be difficult, that's difficult to wrestle with. And I spent a lot of time thinking about it. But I think that when you look at the definition of action on a judgment, every judgment essentially gives rise to a new lawsuit called an action on a judgment. So in order to renew past the 20 years, just like a regular civil action, in order to have that right to sue to extend the deadline, one must file a new lawsuit on an action on a judgment, not merely file proceedings.
It seems like what you're giving me is a rationale and a historical reasoning why they're treated differently, rather than really denying that they're treated differently. When you have a negligence action, you've got to file it commence it within the statute. And as long as you do that, you can finish it afterwards. And you're asking us to say that when you commence a collection proceeding, you've got to not just commence it within your statute, but finish it within the statute, or else it cuts off halfway through. And what you gave me is like, well, Judge, look at the history. And that's a reason to treat them differently. It doesn't really deny that you're treating them differently, does it?
I'd have to think about that more. Your Honor. I mean, maybe you're right. Maybe they are treated differently. Even if that is the case, the Supreme Court has already spoken that that all judgments should be, in order to continue enforcing them after the 20-year mark, in order to continue proceedings supplementary or proceedings for garnishment, you have to renew them after the 20-year mark.
See, your position is that nothing that they did as far as commencing these actions qualifies.
Correct, Your Honor. Because each one of them was a proceeding contained within the original lawsuit to enforce the original judgment, which under the cases that I've said, the Massey, the Young, each one, and Bershawn, each one of those were very similar to here, where they filed enforcement actions, be it a garnishment proceeding or a request to reduce the amount to the arrearages amount in order to execute on them. Each one of those is very similar to the Young, Massey, and Salinas precedents.
Can you give, before you go, just give me your best analysis on Salinas as to why why the holding of Salinas, as opposed to the logic or an extension, why the holding of Salinas, which is what we're bound to follow, would apply here, given that it was discovery.
I mean, I think that my best analysis on that is that since it's discovery and aid of execution, it's connected to the enforcement proceedings. And so all enforcement proceedings, including discovery, must end if you haven't filed your separate action to renew the judgment. I'm not sure. I think I'm eating into my.
Yes, you are.
Okay, then I'll refrain.
All right. All right. Rickard, you're recognized.
Morning. May it please the court, Mark Rickard for the appellee. What I think the court is getting at is a question of the enforceability, all these post-judgment. None of those are applicable. What we have in this case is a continuing obligation. It does not reach the level of a final executable judgment. All of the cases that are relied upon by the appellant in this case deal with execution on a judgment. All these post-judgment cases, whether it be execution and levy, whether it be garnishment, whether it be proceeding supplementary, you have to have a money judgment, a final judgment that says this is what's owed and we're seeking satisfaction. Proceeding supplementary specifically are for the purpose of obtaining satisfaction of judgment. When you have a judgment in equity where there is a continuing or ongoing obligation, such as in the present matter, you can't execute on it. There's no fixed dollar amount which can be put in a writ of execution. The case that I relied upon, which is also what the court put in its order, is the Kosh case. That's the Florida Supreme Court saying that it's a difference in a judgment whether you have a fixed amount that is owed versus, or a liquidated amount versus an ongoing obligation. What we have here, and why all of the districts other than this one yet have said that it does not, a statute of limitations does not apply in alimony, is because it's not a fixed amount due. There's no execution issue.
The council, first of all, I don't think this is alimony. The judgment literally says in lieu of alimony. I don't see how everybody thought it was alimony. It literally says it's not alimony. In lieu of alimony means not alimony. So, but in terms of the fixed requirements, I mean, there were fixed things in the 2004 judgment that, the husband was required to do, or they're not. I mean, transfer interest in a company, make certain make the financial payments. I get that some things were reserved, but there were it certainly said judgment on it, right? And it certainly ordered him to do specific things, did it not?
It did. However, that doesn't make the entire judgment executable. In order to do that, you have to have a fixed amount. Let me give an example to the court, and this is a case actually provided by the appellant, is the Webb case.
Does the statute say executable judgments or does it say any judgment?
Which statute are we?
9511.
9511 is for the enforcement of judgments.
Judgments or decrees. It doesn't say
Right.
judgments, executable judgments, does it?
Ninety-five eleven is an action on a judgment or decree of a court of record of this state. But as an example, again, proceeding supplementary, the courts have found that that's not an action on a judgment. That it's a proceeding within the same case. You don't have to file a separate action. It's similar to what Your Honor referenced before, where if you have a continuing proceeding within the same case, you don't have to file a new suit.
Under that rationale, wouldn't judgments just never expire?
Judgments in this instance would not. If you had permanent alimony, it would never expire until the death of the party. In this case, the ongoing obligation was until 2024. So that's the date that it would
Yeah,
expire.
I'm not buying this as alimony. So if you
Well,
want to convince me, I
that-
don't think it was alimony. It literally says it's not alimony.
But it's an ongoing obligation. And that's what the courts refer to. The Kosh case doesn't say alimony, it says ongoing obligation. It's kind of a semantics there. If there's,
Similar to the Supreme Court's case, I can't remember the name of it, that looked at the mortgage requirement because the mortgage was ongoing, that there would be some default, but they said that the stuff that had defaulted in the past was gone. So you're basically arguing that if it was over 20 years, you couldn't go back and collect that, but the stuff that was continuing wouldn't default up to this point in time.
if I could, and that, look, we go back and I filed a notice of supplemental authority that the case of Dickinson v. Sharp, and it's a 1927 case from the Florida Supreme Court. But the justice who wrote the opinion gave a very pertinent analysis of this, saying that a decree, in that case, we were dealing with permanent alimony, is not one which may be paid off and discharged. It runs in installments, so long as both parties are living, unless vacated by order of the court of competent jurisdiction. So in there, you have one that is ongoing until the death. It's not limited by any statutory period. It says, therefore, it is impossible to determine what amount of money will be required to meet the exigencies of the decree. It is clear that execution would not issue upon a decree like the one before the court at this time. And the only way in which an execution would be procurable would be for the claimant under the decree to petition the court for an adjudication against the person against whom the decree was rendered for default in payment on installments of the adjudication, fixing the amount then due and payable while under the terms of the decree for an order execution for a specific amount. Again, we have in this case a judgment of dissolution, which incorporated a settlement agreement, which provided for ongoing payments, which had not even yet been determined as to their amounts. They were to be calculated. They had to have an accountant go in and determine how much money this company was making and how much of that then would be attributed towards
You're
support.
basically saying treat judgments like, any other contractual obligation, right? Where the statute kind of runs from the breach. I'm not sure that's how judgments work. And there's lots of judgments that require, things other than just that pay this amount within 30 days. And we don't say they're not judgments, right? There's judgments for business divorces, right? Business divorces where you're dividing up assets and things. Not every judgment is just pure pay this amount of money. And I've never heard anyone argue that means they're not a judgment like any other judgment for purposes of a statute of limitations.
Well,
You're basically saying like, well, there wasn't any violation of the judgment until he didn't pay. Is what I'm hearing from you?
well, that would be where there was a breach. If you remember, a statute of limitations runs from the last element of the cause of action.
Well, that's what I'm saying. I don't think if anyone is breaching a judgment. A judgment is not a contract. A judgment is a judgment. And, you violate a judgment, and can be subject to, collection proceedings if it's to pay money or, other remedies for other types of judgment. But That's what I'm saying, kind of the analogy you're making of like, this is a breach of the judgment and it would run from the violation. I'm just not sure that's how judgments work for purposes of statute of limitations.
Well, for a typical money judgment, it is. Because a typical money judgment is for an amount certain on the date the judgment is entered for which execution issues.
Let me ask you this, with a typical money judgment that just says, pay this much money, pay $10,000. You get in Florida 30 days to pay before you're subject to collection proceedings, right?
Well, yes and no.
Okay.
The execution on a judgment is it's immediately due and payable in full. But there is a 30-day stay in order to execute on it because you have the period in which a review can be requested. So they do have a statutory stay period. So it doesn't change the date in which the amount is due in full and in total, which is when it's entered. But you can't enforce it because there's a stay period. That's different than saying when it's actually owed.
Question. This judgment initially basically had payments from 2004 to 2014, 2014 to 2019. Do typical money judgments have that?
Well, the judgment had payments due from 2004 to 2023.
Right, well, I'm just saying, it was, the first set was 2004 to 2014, 146.9, 2014 to 2019, 100,000.
Okay.
Do typical judgments you get when you don't pay your car off or something say, hey, pay this much money every year for the next 20 years?
No, you're going to get a full amount. It's going to liquidate the amount. This is an unliquidated amount. A final judgment that is executable has to have a liquidated amount. And that's the issue that we're dealing with here. That's if it were liquidated, it would be a different question. But again, I wanted to point the court to Webb, which is one of appellant's cases. The second DCA, this is from 2020. Now that dealt with a property settlement agreement, which was liquidated. But in that case, they said that there is a 20-year statute of limitations that ran from the date that it was liquidated, was the date of the judgment. And they said it is 20 years. They said that because her motion to enforce was, quote, an action on a judgment or decree or a court of record of the state, end quote, that when she filed it one day before the 20 years expired, that was sufficient under the statute. It's like Judge Mize was saying that once you file it, that's it. It's a limitation is when do you file it? So even if, well, I'm saying the statute does not apply because it's unliquidated. But even if you apply the statute, it has to apply, and we filed the motion prior to that expiration. And that's sufficient.
I get you have issues about when the statute of limitations started. But assuming the statute of limitations started in 2004, do you agree with me that and you didn't renew the judgment, 20 years you're cut off from filing new things, right? So I'm not asking you to see that the statute started running in 2004, but just assume it did for purposes of this question, right? I'm not taking it as a concession. But you couldn't go down and file new proceedings supplementary, could you?
Well, two questions. You can't file a new action if there's no cause of action to file, we've already got it. Proceeding supplementary require execution. Proceeding supplementary to execution. So you can't ask for a proceeding where the condition precedent is that you have outstanding execution and the
I guess what I'm
legislature
saying
said
is,
you have to file an affidavit.
do you agree that the statute of limitations, it does cut off new collection proceedings after 20 years from whenever it starts running?
On whatever amount is executable, yes. On the money, on the specific value, and other cases, it's not even money, it's exchange of property.
Okay. I get you have a theory on when the statute starts running, and I'm not agreeing or disagreeing with it. I'm just asking you, whenever it starts running, 20 years from that, unless you've renewed it, you can't file new writs or collection proceedings, correct?
Well, correct in a sense, but let me back up because there's a statute of repose which runs from a date certain. That when an event occurs, you have a statute of repose, which is a cutoff point. A statute of limitations is different, and it runs from each cause of action. It doesn't run from a date, it runs from the last element of the cause of action. And when you're filing for a money judgment, it's when was that accrued? If payment is due in 2023 and you don't make the payment when it's due, that's the last element on a claim for the amount owed.
All right,
So-
so I understand your theory on that, but when I ask you a question, I want you to answer my question. Give me the answer to my question.
Maybe I didn't understand it.
So whenever it does start, statute of limitations, it begins. You got 20 years. At the end of that 20 years, you cannot file new collection proceedings, can you? Unless
If
you
it- if
renewed
your
it.
claim is expired, no, you cannot.
I want to ask you about the prejudgment interest. Because it didn't seem in your brief that you disputed that the accountant's report was hearsay. It didn't seem like you disputed that the former wife had no independent recollection that could be refreshed. That's the only argument made by the appellant, and you just didn't dispute it at all. Your argument seems to be that not calculating interest in the prior judgment was a clerical error. And number one, I can't see how the purposeful decision of a trial court not to calculate something and save it for later could be a clerical error. When the trial court purposely does something, that seems to be the opposite of clerical error. And then even if it was a clerical error, I'm not seeing how that has anything to do with, all right, now that the court is in a proceeding to correct it or determine prejudgment interest, the fact that it was a clerical error, I'm not seeing why that has anything to do with whether this report was hearsay and whether it could be relied upon to determine the amount of the prejudgment interest. That seemed just to me to be totally non-responsive to the issue. The only other thing I said, saw you say in the brief was that they didn't give an alternative calculation, which again, just has nothing to do with whether this document was hearsay and whether it can be used to refresh our recollection. So I've got an argument from the appellant. This was hearsay. It was preserved. They made that argument below. They made it with us and said, this is not your client testified. She didn't have an independent recollection. That seems to be what the transcript said. I've got you not responding to that argument at all and giving me two arguments that seem completely to miss the point. Other than what you stated in your brief, is there any realistic argument that we should not reverse in the prejudgment interest?
Yes, the court did award interest. In the judgment, the court said that it would earn interest on it. It specifically says that.
Well, counsel, I'm not saying that the original judgment didn't award interest, but you now had a hearing where the amount was determined, and that was an evidentiary proceeding. And they made an evidentiary objection, which seems to me you do not dispute their objection was correct. So the issue was not whether or not the original judgment awarded interest. The issue was whether the rules of evidence were followed at the proceeding to determine that amount of interest. And it doesn't seem to me that you dispute at all that the rules of evidence were not followed. They made a valid objection. The court erroneously overruled it. Where am I going wrong?
Well, the evidence that we presented was the testimony and it was refreshed.
The counsel, she said, I don't know this. I can only read off the paper. I mean, she said, I don't have an independent recollection of this.
Right, but those papers were record documents because those were obtained by the accountant who was ordered by the court to do these calculations.
It's what rule of evidence allows a witness to read any document from the record, regardless of whether they have any personal knowledge of it.
Refreshing recollection allows you to look at any document.
Yeah, refresh.
Well, she did.
It allows you to refresh a document, to look at a document that refreshes your recollection. She said, I don't have any recollection. I can only read a document. That's not a refreshing recollection. That's their point.
I don't recall that specific testimony off the top of my head here, because my recollection of it, what transpired was that she was saying that she knew at the time and that she had this document which would refresh what she knew at the time.
But let me ask you, at the time, she got it from a out of court person, the CPA. She did not calculate the interest herself. So at the time, she would have got it from a third party, did not calculate it or check it, and then it was brought into that hearing.
Yeah, this was the presentation of the accountant as ordered by the court to do the calculations that were presented to the court in the original hearing. So the court already had those. They were already reviewed by the court initially. They were not, for unknown reason, included in the judgment. And I can't answer
Well, the fact
as
that
to
they
why.
have been included in the judgment years ago doesn't mean that you get to just go read everything from the record back into a party who didn't have that information and that knowledge at the time.
Well, there you get into the argument that the judge relied on, which is the estoppel and the prejudice. That when you have over $1 million worth of interest that is accrued, and that
You're asking us to just start letting trial judges pull a number out because they think equitably, this is such a large number. We've got to throw something on there without getting it on paper through proper evidentiary channels?
Well, you've got the numbers, the principal numbers in front of you. It's not something that's just pulled out of the air. The calculations actually make sense when you look at the record of the payments that were there and the actual numbers themselves. And the interest rate
You
is,
don't get to pull out numbers and say these make sense. You have to get them in through some proper evidentiary tool, right? And in this case, you had a witness who said, I don't know these numbers. I can only read a document. I have no recollection of these numbers. Just because there's some document and you say, Judge, I think this makes sense. That's not how evidence works, is it?
well, then it can be remanded to the court to take additional evidence. Because the prejudice is enormous in this instance.
But I mean, the
And-
parties get to just not meet their evidentiary burden and then say, give me a do-over. I didn't put in evidence for my claim.
In this case, you're not dealing with a principal claim. You're dealing with a mathematical calculation that is the court's responsibility, not the parties. That was the Florida Supreme Court that said that. It is a responsibility of the court, not the party, to do the calculation of interest.
And we know what the judgment is to base it upon. That, we don't have that in any document. We only have that through her testimony.
I'm sorry, Your Honor, we don't have what? We did.
The amounts upon which to determine the judgment.
We have the original documents that were prepared by the accountant.
The accountant didn't testify.
The accountant, I don't believe, is available to testify.
Okay, well, you don't just get to bypass the rules of evidence because you say, well, I couldn't find this person. Like, you have to find some way through the rules of evidence to get your evidence in. Aren't you, counselor? I mean, isn't that what the rules of evidence are for?
And also, couldn't you have another accountant do the same calculations and bring them in? Just because that first accountant may not be here anymore, you could still present an evidentiary basis at the trial.
Which is why the proper procedure, if the court doesn't accept this, would be to remand it for an additional evidentiary hearing to determine those amounts. You're dealing with what would be an error of the court.
We're
This
also
was-
dealing with an error of the course.
Well, again, I mean, but this is something that is ministerial. It's not the burden of the party it was already presented and wasn't included.
But to Judge Rapel's point, why would we send it back for a do-over when the attorney could have brought somebody in then? You know, why should we send it back and say, okay, go get a different account because you chose not to get one the first time?
Well, we had no objections to anything that we presented going into the hearing. And, without even knowing that at the hearing that they were going to bring up these objections.
Was there some deadline for them to make objections? Was there some scheduling order they violated, and then did you raise that at the hearing?
Well, I think I don't actually remember what was said at the hearing.
Unless
I'm
you've
not gonna
got,
represent-
unless you've got some deadline they violated to give you an objection, and then you raising that at the hearing saying, Judge, they missed their deadline to object. I'm not sure why it's relevant for you to say, well, we didn't know they were gonna object, like you.
Well, you don't want surprise argument at a hearing.
But
so
the way-
reasonable time.
The way we deal that is to set deadlines, and then if somebody, and you can ask a trial court judge, we've got a hearing coming up, can you set us some deadlines? Happens all the time. And then if they violate those deadlines, then you raise it at the hearing. I didn't see anything at the hearing where you said, hey, judge, they had a deadline to object to this. They didn't object. They blew the deadline. There's nothing like that on the record.
Well, I agree that if we had asked for deadlines and had them set, that you'd have that. But without those deadlines set, it has to be a reasonable time.
Okay.
Counsel, you're a minute over time.
Thank you.
Thank you, sir.
Counsel, you're recognized.
Thank you, may it please the court. I'd like to spend the last few minutes of my time trying to respond to some of Judge Mize's questions during my presentation. I believe one of the questions you asked was, when did the garnishment proceeding begin in Bouchon? In that scenario, that case involved a foreign judgment. And so it actually had begun 11 years after the original judgment, but I think it was technically 5 years after the writ of garnishment petition was technically 5 years after it was registered. And the court found that that it was untimely. And I think that the larger point that Your Honor was moving towards is the definition of proceeding, and that had they started the garnishment proceeding prior to the expiration of the 5-year deadline for foreign judgments, would that have changed the result in Bouchon? And with respects to, because of Salinas, though, I do not think so, because I know that Your Honor wants to limit Salinas to discovery and aid of execution, but I believe the judgment was a bit broader, because the Supreme Court on page 571 said that for the reasons that follow, we agree with the fourth district holding for Sean that collection activity, all collection activity on a federal judgment is not governed by section 9511(2)A, but instead is permitted for the 20-year life of the judgment. So I think that while the facts of that case certainly involved discovery and aid of execution, the breadth of the holding in that case was much broader and involved all collection activity.
Well, can that be possible? I mean, so an opinion saying, just saying a line, we agree with this, doesn't make that the holding, right? I mean, that's the whole thing, is dicta is something in the opinion said by the court that is nonetheless not a holding. Right? And so what you just said was, despite the facts being discovery, this is still a holding. And that seems to me to just be completely violated of the Pedroza analysis, right? Pedroza tells us holding is based on the facts. So I don't see how you can ever say, despite the facts, the holding is this. That seems to be the opposite of how you determine a holding.
Other than the fact that the court also approved the Bershawn decision in general, which it did go through the analysis and found the statute of limitations applied. And in terms of the definition of proceeding, I think that the Salinas case goes into that and talks about, yes, it can be a broad definition, but in the context of 95.011, the Supreme Court of Salinas did not think it was quite as broad because, and that's provided, that discussion is provided for at page 573, where it says that if proceeding in this context meant any step of a lawsuit, as the judgment debtor seems to suggest, then the statute would require the lawsuit to both begin and end within the limitations period. As the final hearing or trial would be barred if it hadn't occurred after the end of the limitations period. But the legislature didn't state that. It's emphasized that the action had to be begun before the 20-year period. And 95.011 defines action to include, to be encompassing of both civil actions or proceedings. So the entire independent lawsuit had to have been filed within the 20-year period. Merely filing other forms of final processes was insufficient. Therefore, this court should reverse all of the orders that are on appeal and remand with instructions to cease all collection on the 2004 judgment. Thank you.
Okay, thank you. Anything else? Nothing. All right. Court's in recess. Thank you.
Which one is here?
All right. All right, we're back in session. Our second case today, Universal Property and Casualty versus Gonzalez and Cuevas. The attorneys could please introduce themselves for the record.
Good morning, Your Honors. David Noel on behalf of the appellant Universal.
Morning, Your Honor, Michael Cassell on behalf of the appellees, Nelson Rodriguez and CITED.
All right, and how much time would you like to reserve for rebuttal?
5 minutes, please.
Counsel, you recognize.
May it please the court. We're here today to resolve a pure legal question under this court's de novo review. And that question can be boiled down to, based on all three of the briefs, the following question. Can an insurer waive the statutory and contractual ACV provision in the insurance contract by denying coverage? And the answer to that is no. Now, there is a conflict between the DCAs on this particular question. The first DCA to issue a case directly addressing it was the third DCA in the Citizens versus TO case. And they said, yes, that provision can be waived. The contract can be rewritten by denial of coverage. The fourth DCA came next in the Qureshi case, and they said, no, we can't use waiver to rewrite the insurance contract, and they certified conflict with TO. Most recently, we had the second DCA issue their Brito opinion, and in that opinion, the second DCA agreed with the third DCA and TO and said, yes, we can use waiver to rewrite the insurance contract, and Brito did certify conflict with Qureshi from the fourth DCA. And then even more recently, the second DCA issued the Weston case, which also followed Brito. So there's that conflict in the DCAs, although it is important to note for the second DCA, there's a tension within their own case law, because back in 2016, the second DCA had issued a case of Citizens versus Amat, which we do cite in our briefs. And that particular case held, and this is a quote from Amat, Citizens' determination that the homeowner's claim for damages was not a covered loss under the policy did not change the scope of coverage that it had contracted to provide any more than it eliminated the policy deductible or the policy limits. And the issue in Amat was whether in a sinkhole claim, the requirement that subsurface repairs must be entered into contract for by the insured before they became payable. The argument was that Citizens waived that requirement of a subsurface repair contract by denying coverage.
So I'm glad that you went through an overview of these companion cases, because I have some questions related to the contract that's involved in this case compared to the insurance contract that was involved in some of those other cases. So is the contract subject to these instant proceedings distinguishable at all from the contracts in TEO and Brito?
So the contractual provision regarding ACV is the same provision because it does come from a statute. It's in all of the homeowners policies simply because the Florida legislature required it in 627.7011. But we can't just read that in isolation, of course, in the policy. This policy has a lot of different policy provisions, and it also has what's called a loss payment provision, which specifically contemplates that payment would be issued after a final judgment from a court. And it says we would issue payment 60 days after we receive your proof of loss, and there's entry of a final judgment.
So in this instant contract, what is the provision that would require an insured to repair the property before being entitled to the full cost of the loss in a case where an insurer breaches the policy itself?
So it's the loss settlement provision, which says that we must initially pay actual cash value, and then we will pay the additional costs of performing the repairs.
So doesn't it say covered property losses are
It-
secured?
It does, Your Honor, and that's what the Brito case pointed out. But we did file a supplemental authority, a federal case called Polly, and it sort of points out, again, regarding Brito, that if you only treat the contract as giving a provision to pay for covered losses, then how are uncovered losses paid? Are we removing everything from the contract? Does that mean the deductible is now gone, the policy limits? You can't just limit the payment provision in the policy to a claim where the insurance company initially accepted coverage.
So is it Universal's position that the loss settlement section of the instant insurance contract, does that constitute a coverage limitation?
Yes, absolutely, Your Honor. It is a coverage limitation, and that flows to the Florida Supreme Court precedent. There's multiple cases from the Florida Supreme Court that provide guidance to this court. And the first one is the Manor House case, Citizens versus Manor House, where the Florida Supreme Court held that the contractual amount due to the insured is the amount owed pursuant to the express terms and conditions of the policy.
So I'm looking at the law settlement provision here. And I'm looking at, first, when we're talking about building, screen enclosures, whether it's coverage A or coverage B, we're looking at replacement cost. And then it goes into some subparagraphs and looks at, how particular payments are going to be made. Wouldn't you agree with me that the law settlement section just prescribes how and when the payment of covered losses is to be divvied up?
Your Honor, I would phrase it differently than that because the case law defining the distinction between a forfeiture provision and a coverage provision, it does include language that says a provision that delineates the dollar amount of liability is indeed a coverage provision. And that's exactly what this provision does in the contract. It delineates the dollar amount of liability. Do we have to pay the ACV amount, which is lower, or do we have to pay the RCV amount, which is higher? So that brings it within the category of a coverage provision. And also, if we think about the definition of forfeiture provisions, it means that you initially had coverage for a loss and then you lost it because of something you did or something you didn't do.
So along the lines of that argument, you taught us, at least in the brief, that it's Universal's take that TO kind of got it wrong, right? And you cite to the Manor House case. What was the question that was specifically certified to the Florida Supreme Court in Manor House?
Manor House was regarding whether extra contractual damages could be recovered because they were contemplated by the parties entering into the insurance contract. And the Florida Supreme Court said, no, you can't get extra contractual damages. I think it was lost rental income in that particular case. And the Florida Supreme Court came down and said, we go by what's in the policy. Your damages are part of the insurance contract.
So in the instant case here, are the damages claimed by appellees extra contractual or beyond anything the contract actually provides for?
They're extra contractual in the sense that no repairs have been made. So they're claiming damages, and they did claim damages at trial, and the jury awarded them for unperformed repairs.
But I think now you're getting into maybe some of the equitable doctrines that have been discussed in TO and Qureshi and Brito. Isn't there an equitable component to this as well? I mean, I'm a trial judge in Seminole County right now for a family of husband and wife, 3 kids. It's $100,000. You have to have a combined income to be living in Seminole County as a family. If we expect insureds to have to pay the cost of this stuff first, aren't we creating a situation where it's impossible to defend against a breach claim?
Well, no, Your Honor, it's not the case because the breach claim can be for actual cash value. So the insured in a denied claim like this particular case could sue the insurance company and recover actual cash value damages. So there's no blockage or barrier to them filing suit. It's just a question of what damages are you contractually obligated to. And if you haven't yet made the repairs, you're obligated to actual cash value. But it doesn't mean you have to pound sand or you don't get anything. That's not the case.
So is Universal asking that we take a closer look at Qureshi and fall in line with maybe that logic?
Yes, Your Honor. Qureshi decided the issue correctly, and so did the Amat case from the second DCA, which came before these more recent cases.
So with Qureshi, are there any facts that are specific in Qureshi that would distinguish it from, for example, the holdings in TO or Brito, or the fact pattern that we have in this particular case?
So Qureshi, there was a payment issued on a mold claim. It was the mold limits for $10,000, but the water damage claim, nothing was paid on that particular claim. So the facts are not identical, but what Qureshi essentially holds, and it comes from Florida Supreme Court precedent, especially the Doe case, is that an insurance contract cannot be expanded by waiver or estoppel. And that's exactly the case here. We have a provision that delineates how liability is going to be determined, how damages are going to be determined, and to allow recovery for unperformed repairs and for matching costs and for damage that may happen in the future. It's estimated, but we don't know if it's ever going to actually occur during the repair process or if the repair process is going to take place. that's an expansion of coverage. And the Florida Supreme Court case law and Qureshi tell us that that's not something that can be done through waiver or estoppel.
But wasn't it important, it wasn't an important consideration for the fourth district related to the fact that in Qureshi, the homeowners already sold the home. I mean, they didn't even have that house, right?
That's correct, Your Honor. That was an issue in the case that sort of closed the door permanently on replacement cost value, but it didn't really affect the analysis of can we waive the actual cash value provision. It was just an issue of, okay, replacement cost value, it's not something that you can get under certain circumstances in this case because you did sell the property. So you can never make those repairs. In this case, if the repairs are made with an actual cash value recovery, then replacement cost value would be available under that contract. And it does flow back to the Florida Supreme Court, like I mentioned, Manor House and the Doe case. And in addition, the Florida legislature, because up until 2010, 2011, actually, prior to 2011, that statute 627.7011 always required the insurance company to pay full RCV, regardless of if repairs are made. You had to pay everything to replace this damage potentially in the future. So in 2011, the Florida legislature amended that statute and completely changed the language, which is why we have the ACV provision in the policy now. And it changed it to require initial payment of actual cash value and then any remaining amounts necessary to perform such repairs as work is performed and expenses are incurred.
But I mean, jumping back to the statute, subsection 3A, I mean, the plain language, for a dwelling, the insurer must initially pay at least the ACV of the insured loss. Here we're in a situation where there's an alleged breach. So how does that impact your argument?
Well, Your Honor, we still reach the same end result of an insured loss or a covered loss because that's what the jury told us. So it's not that we're going to focus on was the claim denied or was the claim accepted. We're going to focus.
But go back to the statute.
Yes.
You're answering this question as though there wasn't a denial. The statute clearly seems to be indicating that there is a time when the insurer has to decide whether you're going to pay or not. And then you can go actual cash value. You're wanting to jump and say, you've got to go all the way to the end. When a jury has done this, and homeowner, you better have gone out and determined what the replacement cost value is. You're not going to get an actual cash or reverse that actual versus replacement. That's your position, is that the only way you get there under this statute is to go all the way to a jury trial, and then you get to go back and have your cake and eat it too.
I would frame it slightly differently, Your Honor, because there's nothing in the statute or the legislative history or the contract that says this provision goes away if the insurance company denies coverage.
But we're not going to start talking legislative history and getting into that, but we all know what was happening back then is homeowners were taking the money and going, thank you very much for the actual replacement value, but not doing anything to actually repair their house. And somebody else is coming in and nothing was ever done. That was what was driving it. And that's kind of public knowledge, but we're not going to go examine the legislative history. We have the language. The language that Judge Brzezinski just read to you has clear indications that you expect the insurer to make a decision then. And you didn't do that. So why should a homeowner then go to trial and have to ask for something other than what their replacement, their actual damages are?
Well, because, Your Honor, until the repairs are actually made, those expenses aren't incurred and the damages are the direct physical loss. So we're not saying the insured can't recover for the direct physical loss. That's what actual cash value is. You just have to depreciate it and it can't include any matching costs. So there's no block to the insured recovering damages. It's just an issue of what is the measure of those damages. And that is a coverage provision under the policy that can't be waived. Now, also, Your Honor, it's important to note a distinction between this case and all the other case law. And that's that the denial here was on post-loss obligations for lack of cooperation, failure to provide documents, failure to sit for a recorded statement. The denials in Brito and Teo and Weston, those were on coverage. This loss is not covered. You know, Weston, it was a roof replacement. Roof replacement's not necessary. In Brito, it was the loss is not covered under the all risk policy. None of those were denials of coverage for post-loss obligations. And that's an important distinction because the post-loss obligations are entirely within the control of the insured. So if we're going to say an insurance company denies coverage on post-loss obligations because the insured didn't cooperate, and now the insured can go to trial and collect a higher amount of damages, isn't that sort of giving a perverse incentive to not cooperate and get your denial on that specific type of issue? Ensure there is a denial and the insurance company doesn't issue you a payment that you're going to be unhappy with?
Shouldn't that argument be reversed, so that there's a perverse incentive for the insurance company then not to grant the claim, and then to wait until a jury trial, and then to be able to go back and argue that they only have to pay the lesser amount if and until you go back and actually replace it?
I would say no, Judge, because the litigation costs the insurance company money. And if they were to engage in that type of claim practice, there's the bad faith statute where they could be subject to punitive damages, state action. So the insurance company is highly regulated and they would not be able to pursue that kind of strategy. I see I'm into my rebuttal time, Your Honor, so I will sit down now. Thank you.
Okay. Counsel, you're recognized.
Morning, Your Honors. Michael Cassell on behalf of the appellees. May it please the court. First issue I do want to raise that was not raised in the initial argument is whether the defense regarding payment of actual cash value needs to be raised as an affirmative defense. That was in our brief, and I believe it's tantamount to this court's analysis. An affirmative defense is something that admits that there is a cause of action, but seeks to avoid the liability. Here, the entire time that this case has been ongoing, or the lower court this was ongoing, the insurance company said there was no liability. There was no.
I read that in your brief. I mean, it looked to me like the homeowner's argument was, look, you got to affirm based on Universal's failure to plead those damage issues. Either I think it was a motion to eliminate, or some sort of motion for a directed verdict as an affirmative defense. But I mean, we're talking about damages. Isn't damages a basic element of a breach of contract? Does that really need to be raised as an affirmative defense?
Well, what we're seeking as actually, what we're discussing is a limitation on damages. And as counsel stated during his argument, it's absolutely a coverage limitation that they're seeking to enforce. So that kind of gets into the analysis regarding the type of policy we're discussing. It's an all risk policy. All risk policies mean everything is covered unless otherwise excluded. This is also a replacement cost policy where the loss settlement provision states that covered property losses are settled as follows. We will pay replacement costs without reduction for depreciation subject to the following. And then it lists all of these limitations, including the requirement to pay only actual cash value at the onset. So to answer your question, Your Honor, if the insurance company is seeking to limit those damages, yes, they must plead that as an affirmative defense. It is their burden to prove the depreciation in this case as a limitation to the policy. Under an all risk policy, the burden is first to prove that coverage exists by the plaintiff. The plaintiff has to show that there was a policy in effect as of the date of loss. There's no requirement to show that there was a specific type of peril which occurred, nor that there was any specific coverage provision that applied. It's just that a loss occurred during the policy period. After that is then the insurance company's burden to prove its exclusions or its limitations. And I would also note, based on the argument presented here today, that saying something is a coverage limitation immediately takes that out of the coverage provision category and puts it into the forfeiture or exclusionary provision category. Exclusion.
To that point, yeah, I had asked your colleague whether the loss settlement section of the insurance contract acted as a coverage limitation. What's the homeowner's position on that?
So the coverage portion of that provision is the replacement costs language. It says we will pay replacement costs without holdback of depreciation, subject to the following. After that, it's limitations. Because it's a limitation, it's tantamount to an exclusionary provision. And similarly, because the provision says that we will pay you the actual cash value until you do certain things, if those certain things aren't met, namely performing the repairs, then you forfeit a portion of the claim. That turns it into a forfeiture provision. It's not black and white that one section is coverage and one section is forfeiture or one section is limitation. Each sentence has to be read together, but each sentence can serve a different purpose. And frankly, with regard to the policy itself, when you're talking about coverage provisions, you're talking about, as counsel stated, provisions which provide dollar amount of liability. That's policy limits. That's the coverage provision. We will provide coverage subject to the policy limits for coverage A dwelling up to a certain amount. The replacement cost falls in line with that. We will pay the replacement cost of the loss subject to the following.
It sounds like the homeowners are taking the position that it was the opposite of what your colleague responded, which the loss settlement section is essentially a way that any money's paid, or that's just going to be simply how they're divvied up.
I don't know that it's simply how they're divvied up because it's subject to a limitation, subject to a reduction of an amount based on complying with certain policy provisions. That is inherently a forfeiture provision.
Do you agree with your colleague that the contract in this particular matter not really any different than in the TO Greedo case?
I would agree that it's a standard homeowners policy with the same language as it relates to the loss settlement provision. Yes.
From your client's perspective, what's the defining difference as far as Manor House is concerned and Manor House's applicability to TO?
So Manor House is interesting. It's interesting that it's raised in this manner. I guess pun both unintended and intended.
I like a good dad joke, so.
Well, Your Honor, I can keep them coming. Manor House was against Citizens, and Citizens is immune from statutory bad faith. In Manor House, the court awarded extra contractual damages beyond that which were contemplated by the contract. I think in that particular case, there was no coverage for loss of use or rental income, something along those lines, and they were still awarded that as an extra contractual based on consequential damages being awarded. In this case, we're not seeking damages beyond the contract. The damages we're seeking, in fact, are contemplated specifically by the contract, the replacement cost damages without withholding depreciation, subject to the waiver of the limitation that actual cash value will only be paid at the onset. Here, of course, actual cash value is not paid because the claim was denied. And frankly, I don't think the fact that there was a denial of post-loss obligations versus a denial based on the cause of loss or an excluded peril matters one iota. It was a fully denied claim, and it was a breach of contract as a result. And we learn on our maybe first week of law school that when a party breaches a contract, they no longer can enforce the terms of the contract.
Should the court be concerned with if the court were inclined to side with the analysis in Brito and TO? I mean, don't those cases kind of limit the ability of an insurance company and insurer to negotiate a contract by some of the equitable doctrines that are invoked in those opinions?
Well, I'm not sure I entirely understand your question, but I will note that there is no negotiation in an insurance contract.
Well, in Qureshi, I think the court really rejected the application of many of the doctrines like prevention of performance, right? Because the insurer didn't do what they were supposed to. They treated that as a condition precedent. And obviously Judge Warner dissented in that extent, but who got it right on that one?
So I will note that the prevention of performance is more of an equitable doctrine akin to the doctrine of good faith and fair dealing. It's if somebody shows up at 5:05 when the contract says 5 p.m. and the party locks the gates and doesn't allow them to come in, that's prevention of performance. Here, it's more akin to the Brito case, and even after that, the Weston case, which was the second case to come out recently in the second DCA. And the Weston case really spells it out very well. And they say that it's the insurance company is trying to say they want you to sue for ACV. They want you to then, if you win, resubmit a new claim, assuming there's no statute of repose or statute of limitations issue. Then if they breach, you can file another suit. And all the while, they want you to have done the repairs without any kind of guarantee of the coverage that was paid for under the policy. And specifically, the Weston case states, this approach places insureds in an untenable position of paying for what they contend should be covered by the insurer, and then hoping the insurer will have a change of heart despite repeated denials and reimburse them for their loss. Realistically, what should happen in a claim is an insurance company, and this is in line with FIGA v. Somerset, which is cited in my brief, the insurance company must determine both the actual cash value and the replacement cost value at the onset. Once they determine that replacement cost value, That's showing that they have assessed the entire scope and price of the claim. From there, they can withhold the depreciation, but the insured would then know what they are going to get reimbursed after they do the repairs. They're not leaving it up to guesswork. And if you look at the Brito case discusses it even further with regard to the separation of causes of action doctrine, where it states that the purpose of damages awarded on a breach of contract claim is to restore the injured party to the same position that they would have been had they not breached the contract. However, there's no allowance for a second bite at the apple. You have to bring the entirety of the claim as part of the initial claim. When you file a lawsuit, the damages are set in stone, and there's no second bite at the apple after the judgment. So the law presumes that a single cause of action can be tried and determined in one suit and will not permit the plaintiff to maintain more than one cause of action against the same party for the same cause. That's the Brito case citing to Mims v. Reed, 98 Southern 2nd, 498. That's a Florida Supreme Court case, which I believe is binding upon this court. To say that you can get to a final judgment and then you have to start the claims process all over again, and especially now when the statute of repose is limited to 18 months for reopened and supplemental claims, you're looking at, if you want to talk about a term that was used before, perverse incentive, the insurance company would be able to reject the claim, force you to litigation, and then claim later either res judicata potentially, or say that there's a violation of the statute of repose because you haven't presented the RCV claim within a certain period of time. So I believe that to force an insured to go down that path of uncertainty would be massively improper and inequitable.
But I know I'm going back to this, sure. in Qureshi, they relied on that 11th Circuit case, Buckley Towers condo. I mean, didn't they negotiate for that? I mean, this is a part of that insurance contract, is it not?
It is a part of the insurance contract, but it's not negotiated. It's a contract of adhesion. I will also note that Buckley Towers says two other things which were kind of ignored by the fourth. Buckley Towers first and foremost says that the court cannot add additional terms to the contract which do not exist. The other thing Buckley Towers said is the contract doesn't specifically require for the insured to submit a sworn proof of loss that includes depreciation. That's not in there. And that goes back to the argument that it's not the insured's job to submit a depreciation amount. That would be the insurance company's job as the party trying to assert the affirmative of their limitation. So to that extent, I mean, I think Qureshi is distinguishable here for a number of reasons. One, Qureshi was treated as a denied claim even though it was a covered claim. There was a payment issue. Two, the insured sold the property during that lawsuit and could not perform the repairs. So with that, I understand a little bit why there was an analysis that they couldn't recover depreciation because they never would have been able to do that. Now, on the other hand of that argument, if the insured originally obtained coverage and the insured originally performed the repairs based on the insurance company providing information that they would be reimbursed for certain things, they wouldn't have lost money in the sale of the home. But in the Qureshi case, they make it a point to discuss the policy has a diminution of value exclusion. So because there was a diminution of value exclusion, it didn't matter that the insureds lost money in the sale of the home. They ultimately sold the home at a loss at their own peril. I think this case where the claim was denied entirely, where the denial was maintained throughout the entire pendency of litigation, where the verdict form was not simply what are the damages, but rather 13-question verdict form, where the first was, did the insured meet their burden to show that a loss occurred during the policy period? And questions 2 through 12, all related to exclusionary provisions. There's no equitable way to force an insured to then proactively reduce their own claim only so that they can potentially seek a second bite at the apple and a new claim and then have to start all over again.
So along the lines of the denials, Universal's position is, look, this isn't a denial that, hey, we're not covering this. A lot of the denials were related to post-loss obligations, right? And indeed, TO, Brito, not the same type of post-loss obligation issues involved in those fact patterns. How does that impact the argument?
I don't think it does impact the argument. There's a plethora of case law that discusses post-loss obligations and denials of claims waiving the ability to rely on those post-loss obligations. There's also a ton of case law that discusses whether the prejudice analysis that's required. And what Universal is trying to do here is they're trying to make the loss settlement provision, which, and I haven't had a chance to discuss the ambiguity, or I'm happy to if your honors would like, but they want to make the loss settlement provision into some pseudo post-loss condition provision. In order to do that, there has to be a determination that there's been prejudice, because the jury affirmatively determined that there was no violation of the policy conditions, first and foremost. So Universal got that wrong, but they did that at their own peril because they denied the claim. And they never once claimed the loss was covered. They never once claimed that the cause of loss was covered under the policy. In fact, of the 4 defenses they raised, one of them was regarding conditions precedent. 2 of them were related to the loss having been caused by excluded perils. So just because they denied it for some reason, and I know they make a note of this in their briefs, Universal said, well, we had the savings language in our denial letter that we didn't waive the right to assert additional defenses. They were claiming in this case that the loss was an excluded peril. The other thing they were claiming was fraud. They accused my clients of material false statements and sought to forfeit coverage on that behalf. So couple all of that together, they never once raised that the damages should be less than what were sought. And that's something that does need to be asserted, specifically because it's based on a limitation in the policy. With regard to the issue of the loss settlement provision being ambiguous, I think during the initial argument, your honors noted that it only relates to covered property losses. And I believe that's true, but what it says is covered property losses are settled as follows. And there are 2 different potential definitions of the word settled. There's the word settled meaning to pay, and there's the word settled meaning to come to an agreement. I'm sure your honors have seen many cases where we talk about motions to enforce settlement. Those are based on agreements that are reached between litigants. A settlement here, if you insert the definition of pay, or if you insert the definition of come to an agreement, both can be true. Therefore, there is an ambiguity, a latent ambiguity that only applies when you address the facts of the case to the policy itself. If there's a requirement for there to be an agreement for the loss settlement provision to come into play, and there is never an agreement, then the loss settlement provision never applies. And that's why we have lawsuits. That's why we have breaches of contract against insurance carriers. If there is an agreement to the amount, there's not going to be litigation. If they—
It sounded like your counsel was actually suggesting that the covered loss provision can include all the way down the road when a jury determines it's a covered loss. What do you say to that?
Well, I say that the breach of contract occurred likely 2 years before that moment, and therefore there's no way for the insurance company to say, okay, well, we got it wrong, so now it's actually a covered. The insurance company still doesn't agree that it's a covered claim. We're here. If they agreed to it, then we wouldn't be here.
This one doesn't have to be kind of be the payment definition, because I don't think agreements to agree are enforceable. Right? I don't think you can have a contract that says we agree, we'll agree later to something.
I don't think this provision says we agree that we'll agree later. I think it says that once we agree, this is how it's dealt with. And there's the lost payment provision, which counsel discussed as well, which is it has 3 different provisions. It has whether an appraisal award's been paid, it has to be paid within 60 days, whether there's been a judgment, or whether there's been an agreement reached. So the agreement reached is part of the lost payment provision, which ties back into the lost settlement provision. You have to look at the policy as a whole and read all of the operative language together. So there's a provision that says, when we come to an agreement, we will pay you within a certain number of days. There's no set timeline in the lost settlement provision, but the lost settlement provision comes back to the lost payment provision in that when there is a certain element met, that there's been an agreement. Actually, I think the lost payment provision says, and I can double check this. I don't believe it's been discussed in the briefs, but I believe the lost payment provision actually says when we've reached a settlement. So if the lost settlement provision discusses a settlement, and the lost payment provision discusses the timeline that payment has to be issued when a settlement has been reached, then looking at those both together, I would say maybe there isn't an ambiguity. Maybe it actually is just the policy is clear. There has to be an agreement for the loss settlement provision to come into play. With regard to the well, actually, Your Honors, I believe I've made all of my arguments. If Your Honors have any further questions, I'm happy to continue. If not, I'll yield the rest of my time. All right, thank you, Your Honor. So with that said, the appellees request that you affirm the final judgment, all interlocutory orders below, and remand this case for final judgment in favor of the appellants.
Counsel, you have 4 minutes and 18 seconds remaining.
Thank you, Your Honor. I want to start with the loss payment provision. It was just mentioned by counsel. And that provision says loss will be payable upon the earliest of the following 20 days after we receive your proof of loss and reach a written agreement with you, which didn't happen in this case, or 60 days after we receive your proof of loss and there is an entry of a final judgment. So this contract between the parties specifically contemplates that a dispute may have to go to a final judgment. There's nothing in the contract that says if it goes to a final judgment and the jury sides with the insured, that parts of the policy disappear or get deleted. It's not in the contractual language, and it's not in the Florida Supreme Court precedent anywhere. To go back to the statute 627.7011.
Before we jump away from
Yeah.
that, one of the arguments that was being made was related to the interpretation of the word settlement. So, you know, let's say there was an ambiguity with that term. I mean, wouldn't cases like US fire insurance require us to say, well, look, we've got an insurance policy here. If there is an ambiguous term, we got to find that in favor of the homeowners. What's Universal's take on that term settled?
Your Honor, that term is unambiguous, as is the rest of this policy language that we've been discussing. And Qureshi reaches that particular conclusion. It says here, the insured's policy is clear and unambiguous. The insureds are not entitled to the repair costs unless and until work is performed and expenses are incurred. And that's really throughout the case law. There's a Florida Supreme Court case called Sabalo that says where there's a provision about work is performed, expenses are incurred. It's unambiguous. It means the work has to be performed before that is triggered. So there's nothing ambiguous here about the word settled or any of the other provisions in here. They work together to say that you get actual cash value unless you've made the repairs. And you can always certainly take that actual cash value, even if you get it from a jury, and you can use that to start making the repairs. And if those repairs are made and now you've run out of money, you go back and you seek the replacement cost value benefits and you complete the repairs. There's nothing here that would require this court to say the insured has to make all the repairs 100% full RCV work before they can get any payment from the insurance company. That's not what the argument is. So to go to the statute, the 627.7011 subsection 3, where it says in the event of a loss for which a dwelling or property or personal property is insured on the basis of replacement costs, that just means that it's a replacement cost policy. That's not imposing a requirement that the insurance company accepted coverage for the claim at the outset. And it's also important to note that the Brito decision was based on the determination of the insurance company pre-suit that the loss was not covered. And as a result, the second DCA said, well, loss settlement provision does not apply. The loss was not covered. We don't have any determination here pre-suit by Universal that this loss was not covered. We just have post-loss obligations. You didn't give us what we needed. This was a late reported claim several months later, and we didn't get to inspect it until even months after that. So the post-loss obligations were significant, and it's very different from what's in Brito. Additionally, if the ACV provision can be stricken from the policy, then where does that argument and rationale stop? Because you can make the same argument about the policy deductible, which in a hurricane claim can be extremely large. It's going to prevent repairs. The insured has to come out of pocket. Are we going to strike that or the policy limits? And that sort of shows the absurdity of the argument if it's taken to the extreme on the plaintiff side. And it would make it impossible for insurance companies to set premiums. If they issue a denial of coverage, how do they know 2 years later, a jury is not going to say, hey, you were wrong? And now it's a completely different insurance contract that they didn't charge a premium for.
But on the flip side of that coin, I mean, if by, you know, this is brought up, I believe, in Brito. I mean, when an insurer denies coverage, isn't it kind of a useless act to require the insured to try to make the repairs when they don't even know if they're going to recover on that?
At that point, they wouldn't have to make the repairs to claim ACV, because to get ACV, you don't have to make any repairs. So if the insurance company denies coverage, the insured can sue the insurance company to determine coverage and then to collect ACV. And then if they choose to use that money to make repairs, they can get the RCV. There's no requirement to make repairs at the ACV. It's just the property that was directly physically damaged, and they could take that money and pay down the mortgage, or they could take a trip with it. We want to encourage the public policy of making repairs, and that's why there's that extra requirement contractually and statutorily to get RCV. So thank you, Your Honors, and for the reasons in the briefs and argued today, we'd request that the court reverse and remand.
Thank you.
Thank you, counsel.
Thank you, counsel. Court is adjourned.